today.
No. What is your question?
Outlined
No,
in the
no, no, Mr.
foregoing,
Elizondo, no.
Your Honor, respectfully, as a bailor and grantor, I've granted this court equitable title for settlement of any
No,
charges
sir.
on
This
the
is a
doctrine
criminal
of
court. No,
trust
sir.
and merit.
Mr. Elizondo.
Your Honor, for the record, respectfully, I am a Texas common law free man. I do not participate in corporate Ponzi schemes that require me to have
This is not
registration
that, sir.
and
This is not
insurance.
Mr.
I do
Elizondo.
not
Stop.
consent. Gave
No,
this
no, let
court
me no,
equitable
Mr.
title for
Elizondo,
settlement
stop. Mr.
of
Elizondo,
any
stop.
charge
Mr.
under
Elizondo,
doctrine of trust
Mr.
merge.
Elizondo, stop.
During the court proceedings, Mr. Elizondo began to speak, stating that he had a question. The judge responded by asking him to proceed. But when Mr. Elizondo began making statements regarding his status as a bailor and grantor, and claimed to have granted the court equitable title for settlement purposes, the judge clarified that this was a criminal court, not a civil or equity matter. Mr. Elizondo continued, stating that he identified as a Texas common law free man and that he did not participate in what he described as corporate schemes. The judge again reminded Mr. Elizondo that this was
Your Honor, my Christian name is Jose and my family name is Elizondo. I am the bailor today and
Okay,
respectfully ask some issues to raise.
wait, Mr. Elizondo, wait. Jose Elizondo, I show that you have one case pending, and that is expired registration. Do you understand that's the charge that is pending against you?
Yes, I understand, but
Okay,
respectfully,
sir. Okay, hang on. There's several steps we need to take over. Were you able to hear my explanation about defendant's rights and
Yes.
options that I went over at the start of court?
yes,
Do you have any questions about those rights or options?
yes.
Go ahead. What's your question?
Okay, respectfully, I haven't received my documentation that I requested in a timely manner to proceed today.
No. What is your question?
Outlined
No,
in the
no, no, Mr.
foregoing,
Elizondo, no. What is your question about the rights and options that I went over at the start of court?
I have no questions regarding that.
Okay, then to this charge of expired registration, actually, I'm going to stop and say you mailed in payment.
I did.
You mailed in $3 and you have a balance due of $129. So with that payment of $3, we've already entered a plea of no contest for you because Texas law allows that to be entered for you. So we're set here to determine, are you able to make the balance of your payment by Monday, or do you need some time to pay that out?
Your Honor, respectfully, as a bailor and grantor, I've granted this court equitable title for settlement of any
No,
charges
sir.
on
This
the
is a
doctrine
criminal
of
court. No,
trust
sir.
and merit.
Mr. Elizondo, this is not a civil court. There are no parties like that in this proceeding. You're a defendant. You're not a grantor. I'm the judge. And so that does not apply to this court. You may have read that might be something in a civil court. That does not apply here. So my question to you, sir, is since you've already mailed in payment and indicated a plea of no contest by mailing in a payment under Texas law, can you get the balance paid by Monday? Or do you need some time to pay that out? Or do you have a financial situation that you need a financial packet?
Your Honor, for the record, respectfully, I am a Texas common law free man. I do not participate in corporate Ponzi schemes that require me to have
This
registration.
is not that, sir.
and
This is not,
insurance.
Mr.
I do
Elizondo,
not
stop.
consent.
Mr. Elizondo, stop. This is not the time to make a statement. You see, we have like 12 other people who are set here. You're set on a criminal charge. This is not time for you just to go and make a statement about a civil matter that it is not set in this court.
So are you saying that I don't have civilian due process of law?
No, but this is not a civil matter. You're raising terms in regards to this as if this were like a civil lawsuit. This is a criminal charge where
It's
you've
not
already.
criminal, Your Honor.
Yes, it is, sir. This is a Class C criminal charge in Texas, displaying an expired registration. That is a Class C criminal charge, and you mailed in partial payment. So I'm trying to determine, are you able to make the rest of your payment by Monday, or do you need some time to pay it out?
I have the right to equitable title for this settlement or any charges on the doctrine of trust merge.
This is
And
not a matter. This is not a
respectfully,
matter
Your
of a
Honor.
title to a vehicle or anything like that, sir. You seem to be confusing some civil law
Well,
with the
I
pending
have
criminal.
some confusion because on Supreme Court case law Murdoch versus Pennsylvania, they clearly state that you don't need registration or insurance for private personal travel, and I don't consent to any corporate Ponzi.
was not applicable to the current proceedings and instructed him to stop. Despite multiple interruptions, the judge maintained order. repeatedly asking Mr. Alzondo to cease speaking out of turn so the hearing could proceed. Appropriately, in a recent court proceeding, Mr. Jose Alzondo appeared before the judge regarding a charge of expired vehicle registration. At the beginning of the hearing, the judge informed Mr. Alzondo that his case involved a single charge and confirmed whether he understood the rights and options previously explained at the start of the session. Mr. Alzondo acknowledged understanding, but then raised concerns that he had not received certain documentation in a timely manner. The judge redirected the discussion and asked whether he had any questions specifically about his
nothing to do with the corporation. This is a Texas charge, and you've already mailed in a payment for this. So you've indicated a plea of no contest. Are you saying that you're not pleading that? Then why
Your
did you
Honor,
give them
as a
$3?
bailior and grantor, I gave
No,
this court
Mr.
equitable title for
Elizondo,
settlement
stop. Mr.
of
Elizondo,
any
stop.
charge under
Mr. Elizondo,
doctrine of trust merge.
Mr. Elizondo, stop. Why did you mail in $3?
Because as a bailior and grantor, I have granted to this court equitable title for settlement of any
No, sir, we do not settle. And,
charges
sir,
under trust
Mr.
merge.
Elizondo, there's no party in a criminal charge that's called a bailior, and you cannot claim a position that is not one in this court.
Your Honor,
There's
are
no
you giving
status
me-
of bailior.
Are you giving me finance?
No, sir, listen, I
Oh.
need you to listen to me. I need you to listen to me. There's no status of bailior or grantor in this criminal court. You may have read some cases in regards to some other matters. You are a
Can you give
defendant.
me-
No, Mr. Elizondo, you need to be quiet and listen. You're a defendant. You mailed in $3, which is partial payment of a total of $132. All right. Now, by law, when you mail in a payment, a plea of no contest is entered. All right. So my question to you was, when you mailed in the $3, was that your intent to make a partial payment, requesting a payment plan, or were you attempting to post a bond?
My intent was, like I said, I am the bailior and grantee. I have granted this court equitable title for settlement of any charges under doctrine of trust merge. That's my answer to your question.
Okay, that is not an answer that applies in criminal court. So based upon your payment of $3, the court has already entered a plea of no contest, and I'm going to order that you get the balance paid
Your Honor,
within 30
respectfully.
days.
Okay, Your Honor, respectfully, with those documents that you have, I didn't receive any documentation requested in a timely manner to proceed today. Outlining my full warranto under Chapter 66 of Texas Civil Practice Code, which
Okay,
is
stop,
provable
Mr. Elizondo,
and
Mr. Elizondo, stop. The Civil Practice Code does not apply to this courtroom. This is the Code of Criminal Procedure applies to the criminal courtroom. So the Civil Code does not apply.
But I still have a civilian due process, Your Honor.
Well,
And I
yes,
have not
but
entered a plea.
you did by mailing it in. By mailing that in, that's entering a plea of no contest. You mailed in a payment of $3.
Your Honor.
You can
Like
get
I
the
said,
balance paid.
The reason why I did that as a bailior and grantor, like I stated multiple times, I've granted this court equitable title for settlement.
Okay,
under
Mr.
any
Elizondo,
doctrine of trust merge.
Mr. Elizondo, were you wanting to plead not guilty and request a trial?
No. Respectfully, Your Honor. Constitutionally, too. For the record, I am a Texas common law free man. I do not participate in any Ponzi schemes that require me to have registration and insurance. I do not consent quasi-jurisdiction. Respectfully, Your Honor, I plead
his rights or options. Mr. Alzondo indicated he did not. The judge noted that Mr. Alzondo had mailed in a payment of $3, which Texas law interprets as a plea of no contest, leaving a remaining balance of $129. The court asked whether he would be able to pay the remainder by Monday or needed a payment plan. Mr. Alzondo responded by referring to himself as a bailior and grantor and claimed to have granted the court equitable title for settlement, language often associated with legal theories not recognized in criminal proceedings. The judge clarified that such designations and arguments do not apply in criminal court, emphasizing that Mr. Alzondo was appearing as a defendant under a Class C misdemeanor charge. Despite repeated explanations from the judge, Mr. Alzondo continued to invoke legal terms inconsistent with the court's jurisdiction, referencing doctrines from civil.
Okay, well, you're
Under Section
receiving,
1, Article 10.
okay, Mr. Elizondo, you're receiving the exact same due process that every other person who's appeared in this court has. And you have mailed in a payment of $3, and that payment is received as a plea of no contest.
Who is my accuser, Your Honor, respectfully?
The state of Texas. That citation that you received, that is the accusation. And
Okay, well, I would like to go to trial for this.
so you're indicating that you wish to change your plea from no contest to not guilty?
Yes.
All right. And you wish to waive your right to jury trial, or do you wish to request a jury trial?
No.
So no jury trial. You wish to waive your right to a jury trial?
1 second, please. Never mind. Give me a jury trial, please.
So you wish to request a jury trial?
Yes.
And you will be representing yourself, or will you be retaining counsel?
Myself.
Okay. Do you understand that if you request a jury trial, if you're found guilty, in addition to the regular state court cost, there is an additional jury trial court cost that's assessed if you're convicted. Your case is going to be reset for a pretrial hearing that is going to be for our May contest docket, which is at 6 p.m. on May 7th.
Law and unrelated Supreme Court cases. The judge reminded him that these references were not relevant to the matter at hand, and that the Texas Code of Criminal Procedure, not the Civil Code, governs the case. When Mr. Elizondo persisted in presenting unrelated arguments, the judge advised him to stop interrupting and focus on the matter before the court. The judge then asked Mr. Elizondo to clarify whether he intended his $3 payment as a partial payment or as a bond.
Coming up next.
Attacked and assaulted and kidnapped 2 different times, just one time. Recite your oath of office, your delegation of authority order, and your bond information.
What is your name?
I am Brian. My family name is Wilkinson.
All right. We'll go on the record in State of Kansas versus Brian J. Wilkinson. Case number 25 CR 67. The state appears by County Attorney Darren Deviney. Mr. Wilkinson appears in person by Zoom. We're here for a first appearance. Mr. Wilkinson, you're appearing by a summons. I'm going to go over your charges with you. There are 3 counts, all alleged to have occurred on June 4th, 2024 in Butler County, Kansas. Count 1 alleges you were in unlawful possession of methamphetamine. That is a level 5 drug felony. Count 2 alleges you are in unlawful possession of paraphernalia for use. That is a Class B non-person misdemeanor. Count 3 is an allegation of possession of marijuana, also a Class B non-person misdemeanor. Do you understand what you've been charged with, Mr. Wilkinson?
I do not understand, Your Honor.
Yeah, what don't you understand?
I had thought that this matter was already settled on the case that Mr. Watts was representing me for.
Okay, I'm not aware of that particular matter. That may have been a different case. I'm not sure.
Well, there wasn't a different case. I mean, I wasn't attacked and assaulted and kidnapped 2 different times, just one time.
Mr. Deviney, do you know anything about another case involving Mr. Wilkinson?
Let's see. Well, I know there's criminal history. I know he's a B on the grid. He has out of at least Butler County cases, we've got a driving while suspended, an old a 23 traffic case that's closed. And then he has this open case now for possession of methamphetamine.
Do you know of, is there one where Mr. Watts representing that you know of?
Not that I'm aware of. Well, Your Honor.
All right. Well, I don't know, Mr. Wilkinson. That can be sorted out. Can you afford to hire an attorney to represent you?
I'm sui juris.
Excuse me?
I'm sui juris, and I would I would appreciate it, Your Honor, if you would recite your oath of office, your delegation of authority order, and your bond information for the
I'm not
record.
going to do that, Mr. Wilkinson. Can you afford to hire an attorney?
I am not a ward of the court. I'm not an idiot. I know how to speak for myself.
Okay. Do you
I
wish to
won't be.
represent yourself?
Well, I am myself. I can't represent myself, but yes,
Are
I
you,
will be talking for myself.
all right. You understand you have a right to have an attorney represent you on this case?
Yeah, but that makes me a ward of the court. If I am seen as too stupid to talk for me.
He reiterated his earlier claim about equitable title and trust law, which the court again explained had no standing in this context. Based on the payment, the court confirmed that a plea of no contest had been entered. The judge asked if Mr. Alzando now wished to change his plea to not guilty and proceed to trial. Mr. Alzando responded that he did not recognize the jurisdiction of the court, claimed constitutional protections under common law, and asserted that he did not consent to the proceedings. The judge responded that all individuals in the courtroom received the same due process and that Mr. Alzando's payment had legally constituted a plea. The judge then explained that the accuser in this case is the state of Texas, as represented by the citation.
Do you understand that if you can't afford an attorney to represent you, one would be appointed for you?
I also understand that all attorneys' first duty is for the court and not for their clients. So
do you
I wouldn't
understand
want.
you have that right, Mr. Wilkinson?
I do understand my rights. Yes,
Okay.
Your Honor.
I'm going to go ahead and appoint James Watts to represent you if you think that he's represented you on something that may be in line with this case. So he'll be with you when you appear back in front of me, and that'll be on my preliminary hearing control docket. Do you have something to write with, Mr.
Yes,
Wilkinson?
sir.
All right. Your
Yes,
court
sir.
date will be in front of me by Zoom on May the 19th at 2:30.
May 19th, 2:30 p.m.
That's correct. Do you have Mr.
Okay.
Watts' contact information?
Yes, I do, Your Honor.
Okay. You might contact his office and let them know that court date. We need to set a bond. Mr. Devaney, what's your recommendation for bond?
Your Honor, the defendant does appear here voluntarily by summons here today, so I'd request a $10,000 OR bond for the defendant.
What was the amount?
$10,000.
All right, I'll set a $10,000 OR bond. He'll need to be processed, I'm assuming.
Well, he initially had a first appearance back on June 5th of 24 at 1:30. At that point, we were waiting on KBI Labs and we released him. So I believe he's actually been arrested and processed.
Okay.
He just needs to come to 201 West Pine. If he can make it here today before 5, that's great. If not, probably on Monday to come up to the front desk so he can sign his bond.
All right, Mr. Wilkinson, can you make it up to the Judicial Center this afternoon to sign your OR bond?
It'll probably need to be Monday, Your Honor.
Yeah. Citation issued. Ultimately, Mr. Alzando stated that he would like to proceed to trial. The court acknowledged his request, confirming that he wished to change his plea from no contest to not guilty. During a court proceeding, the judge asked the defendant, Mr. Wilkinson, whether he wished to waive his right to a jury trial or request. 1. Initially, Mr. Wilkinson appeared uncertain, but then confirmed that he wanted a jury trial and stated he would represent himself. The judge explained that if a jury trial was requested and Mr. Wilkinson were found guilty, an additional jury trial cost would be added to the standard court costs. The case was then reset for a pretrial hearing on the May contest docket, scheduled for 6 p.m. on May 7th, in a separate court appearance. Mr. Brian Wilkinson appeared via Zoom for a first appearance related to case number 25 CR 67 in the state of Kansas. The state was represented by County Attorney Darren Diney. Mr. Wilkinson was appearing in response